Hi, guys. It's Kathy. I hope you're doing well. Michael, I hope you cleaned yourself up from yesterday. If not, go. Go. We don't need that in this stream. Guys, it's hot. Guys, guys, it's too hot. No one can live like this. No one. No one. I don't know how many more days we have to go through this, but my air conditioner was on full blast and it was 78 in my house. Oh, man. 78 is too hot. I'm dying. I'm dying. I need I need help. Like, can't the government send like I don't know, one of the armed forces to come and help us up here in Pennsylvania because we are just hot and people are cranky when they're hot. So my daughter's third day of work. My son, okay, I have two cars. I have my Mazda that's held together by duct tape. And I also have a Cadillac. It's an older Cadillac. Don't nothing It was my mother's, and she made me buy it from her. Like I didn't have an option. There was no asking if I wanted the car. She just dropped the car off and said, "Okay, you owe me money," and I had to pay her money. But it was my mother's car, so I'm not driving that. I'm not driving that. My son drives it, and what I didn't know is that he was having issues with the radiator. And my daughter's third day of work, he had pulled behind me in the driveway so I couldn't move my beautiful, beautiful car. So I'm like, bet, I'll just take his car, I'll drive her to work real quick. No, I overheated. Probably. I overheated and she had to get an Uber and she was 7 minutes late for work on her third day of work. And that is absolutely unacceptable. And then I had to get home. So what I did was I would drive like 6 blocks and park and then wait for it to cool down again and add more water, and drive 6 more blocks and park. It took me like an hour and a half to get home this morning from driving her to work. And I didn't even make it to her work. I made it part way to her work. So I bought him the part that he needed right away because I didn't know. He didn't tell me. He was just he was just driving it overheating. He's like, no, it's okay. I don't really think it's overheating, he said. He said, you could just keep driving. I guess he won't be happy until he blows a head gasket on a Cadillac, which is, it costs at least 3 eggs to fix. At least. At least 3 eggs to fix a head gasket. It's just hot. I just couldn't get the car to cool down because it was just too hot. Even my car is like, no, no, I'm not driving in this weather. I felt bad for the car. I wanted to do something for it and I couldn't. I had to stop in 3 different places on the way to get more water. Some guy in a, oh, what are they called? Cyber truck got mad at me today because when I overheated, I turned off the road and parked on a side road. And side roads are smaller, so he had to wait for one oncoming car to pass before he could get around me. And he was throwing his hands up and he was having a little hissy fit. Dick, I'm sitting here in the hot, waiting for this car to cool down, and you're mad because you have to wait for one car to pass? You're not allowed to attack cyber trucks. Cybertruck? Is that right? I hear it's like really against the law. If you get caught attacking one of those, you get in big trouble. Boy, did I want to today. Boy, did I want to. Anyway, we got a pro se. And when they have a pro se, the judges have to ask the pro se all these questions, all these normal questions. I skipped all that because it's just boring. It's just boring. And I got to the better questions. I love you, Monica. I love you. I might have needed it today. Entitled, spoiled people in this world. I swear to God. All right. I'm not allowed to talk at the beginning of my stream anymore, and I just did. I just keep shooting myself in the foot. It's fine. It's fine. It's all fine. I'll just fix it. So I can't get rid of this because I got Judge Frost today. Remember? Maybe you do, maybe you don't. He's like one of my favorite judges of all time, Judge Frost. Every day before I look for any other courts, I check Judge Frost. And he's never on, ever. He was on today. He was. So I started recording him. And I forgot to stop the recording before I went to work. So actually, I was gone for 14 hours. I've started recording and I didn't come home until 14 hours later because I always go out with a friend after work on Wednesdays. And the 14 hours, this video is still processing. Maybe. And I don't think I'm going to get it. I don't think it's ever going to finish processing. I think it's not going to. But I'm just going to let it go. So we're going to have to just watch this blue dot all stream. And no one can stop it because it's buried too far up to stop. It won't let me pull it down. It won't let me stop it. But I guess, I could stop it easily. Not to worry. But we're just going to have to deal with it. All right. Now that I lost anybody who was going to watch this stream because I babbled on, I'm going to press play. It's too late, but I'm going to press play.
I told you, you have the right to decide against having an attorney, but you must be aware that deciding to not have an attorney can't turn out as a bad decision. Experienced lawyers almost always decide to be represented by another lawyer in a criminal case, and there are some things you should consider before you appear at trial without an attorney. For me to be comfortable with you presenting your own defense, I have a series of questions for you. I've gone over a couple of those regarding your ability to read and understand and speak English, etc. Have you ever studied criminal law?
No, sir.
And have you ever had previous experiences with the criminal justice system?
I have not, sir.
Have you ever been charged with any criminal offense?
No, sir.
And is this the first time you've ever been in custody in the jail?
I've been in jail before.
And from those prior jail experiences, did you ever have charges you had to go to court for?
I've been in a court.
Judge, he just said he's never had any before. And now he says he is. I think he's confused right away. Right from the get-go, this guy has no idea. But it just keeps getting worse.
Before?
Where was that?
It was Superior Court number 1.
Was that here in Marshall County?
Yes, sir.
And it sounds as though you had some prior cases with the criminal justice system. And in that experience, did you ever participate in a jury trial?
No, sir.
What's the highest level of education that you have received?
High school education, level education 12.
So you graduated high school?
No, sir.
You went to the 12th grade, but you did not finish the 12th grade.
Yes.
Is that correct?
It's correct.
And I've already asked this, but I'll ask it again. Are you able to read and write well?
Yes, sir.
Would you consider yourself a good speaker?
Yes.
Explain that to me.
I can maintain the proper language, the English language properly. I can speak it.
When I'm asking, are you a good speaker? What I'm asking is, are you able to speak in front of people?
Yes, sir.
Okay, do you have any prior experiences with public speaking in any way?
I do not.
Can you quickly become familiar with large numbers of special rules and procedures and use them in the right way in a pressure situation such as at your own trial?
I can, sir.
Explain to me why you think you can.
I don't have any issues speaking. I can properly go through a procedure.
Are you able to read rules and then follow those rules?
Yes, sir.
Have there been any promises or suggestions from anyone that you will receive special treatment or a milder sentence if you do not have an attorney?
No, sir. I don't know.
Have there been any threats to you or anyone that you know that you will be harmed or there'll be a disadvantage if you have an attorney?
No, sir.
Explain to me what the jury trial looks like in your mind.
To me, a jury trial is a trial date, court date, intact with witnesses, people who represent the court.
Explain to me what will happen at the trial.
Trial day comes to my presence. I'll represent myself, and the jury trial will represent the court.
Boom. Nailed it. He nailed it. That's exactly what Webster says jury trial means.
I understand you're talking in generalities here, meaning you're just speaking in general terms, that you'll be in court, that there'll be witnesses. But tell me what you understand will actually happen at the trial.
The judge will read me my rights. The judge would also witness every note, every representation given to me. I would have to abide in favor of the judge. I would be given my sentencing.
Nailed
At the initial
it.
hearing, I went over your rights with you. Do you remember that?
Yes, sir.
And what rights do you remember me telling you you had?
I have the right to get an attorney. I have the right to represent myself. I also have the right.
He thought the judge meant wrong answers only. It's more entertainment if it's the wrong answers only. For example, what is the best pie you could absolutely eat? But only wrong answers. Wrong answers only, please. Here we go.
To dedicate any special law education into the trial.
Do you remember other rights that I mentioned?
No, sir.
So you have the right to the jury trial, which we've scheduled. That's one of them. And you know that because you asked for that trial and we scheduled it. At the trial, you would have the right to see and hear the witnesses testify against you. You mentioned that there'd be witnesses called. So it seems like you understand that there'll be witnesses called here at court. Is that correct?
Yes, sir.
And you also have the right to bring witnesses in using the court's compulsory process, which is a fancy way of saying you could force those witnesses to come in. Do you know what that means?
I don't know.
Do you have witnesses that you are wanting to call?
No, sir, I don't.
And so it's not that you need or don't need the court to issue subpoenas. You do not have witnesses in your defense.
Yes, sir.
But you understand that they could be forced to come in.
Yes, sir.
At the trial, the state's required to prove your guilt beyond a reasonable doubt. Do you understand that?
Yes.
Tell me what that means to you.
The state would authorize their testimony.
What do you mean by authorize?
They would dedicate their testimony in favor of the court.
Let's try to speak as plainly as we can here. Okay. You've said authorize, you've said dedicate testimony. What do you mean? And what do you think will happen here in court when the state presents their case?
They would proceed to file against me.
We're talking about witnesses. So what will happen with those witnesses?
So do
Witnesses,
my Riz.
I don't have a witness in my favor.
I'm not asking about your witnesses. I'm asking about the state's.
State witnesses. I'm not too familiar with the state's witnesses. I am familiar with the court system, and I've represented myself before throughout the court.
When was that?
Right before,
I've proceeded.
it was right before I went to jail, Judge. Right before I went to jail, I was representing myself, and then I tried to appeal with ineffective counsel, and they said no.
To attend to court, to child support, to court hearings, court dates.
Let me try to clarify. When was it? As in 5 years ago, 4 years ago, 3 years ago, 2 years ago, 1 year ago, days ago? When did you go to court?
We measure in kilometers, Judge.
Been to court last year.
How many times?
Been to court twice.
And you're not talking about these hearings,
365.
right? You're talking about other courts.
Right.
You know you have the right to an attorney because you told me that today, and then you repeated that saying, what was the right you remembered? You said, I remember you telling me I have the right to an attorney, I have the right to represent myself. At the trial, you also have the right to remain silent, which is you cannot be forced to testify against yourself. And you would have the right to an appeal of any decision made. Do you understand you have those rights?
I do, sir.
Explain to me as best you can why you do not want an attorney to represent you.
Don't worry.
Sir,
Don't worry. This answer, crystal clear. You're going to find out crystal clearly why he does not want an attorney.
I have not made any contact with any attorney. I have information that could help me best with an attorney by my side, but I yet haven't came to any resolution.
I'm confused on what you just said there because
Wait, how are you confused? That was crystal clear, Judge. Judge, did you finish school? Do you understand the English language? Judge, he was crystal clear. And now you're just screwing with him.
the question was, why don't you want an attorney? And your response was that you have information that would help you if you have an attorney by your side.
Yeah, see, you do understand.
So thus far, you've never asked me for an attorney to represent you. You also not hired an attorney. So help me understand what you meant by you have information that would assist you if you have an attorney by your side.
Sense.
Yes, sir. So I haven't made any contact with any attorney, and to my best knowledge, I'm proceeding to continue without an attorney because I don't have the proper way to hire an attorney or to make contact with an attorney. So I believe it's in my best interest to just proceed without an attorney.
Do you understand that I could appoint an attorney to represent you?
Security, thank you. I
Yes, sir.
appreciate it. Thank you.
And you have not asked me for one yet, correct?
Correct.
Why have you not asked for an attorney to be appointed?
I've been proceeding by myself for the past couple of months, understanding my trust within the court or myself.
Mr. Martinez-Vizar, I'm struggling because you have not talked about hiring an attorney, at least from my memory, until today. Meaning in all the other hearings we've had, you've never referenced hiring an attorney. And so I need to ask you relatively directly, do you want an attorney to represent you?
No, thank you, sir.
And why is that?
I'm proceeding without an attorney because it's in my best interest. It's kind of I've already dedicated my side by myself to the court.
Bailiff, could you come here for a minute? Hand this to Mr. Martinez-Vizar. What I'm handing you is the information that I read to you earlier. This is the questions that I just read to you. I want to take a recess. I'm going to have you read that, and then I'm going to have you decide whether you want to
Now, Judge, you need a recess for rum. Don't lie. We all know.
still move forward without an attorney, and then sign that if you do. Okay?
Or
So we'll take as long as you need to read that, and I want you to read it very detailed. And then if you're in agreement, you can sign it. If you're not, you do not have to sign it. Understood?
Are we sure he can read?
I see you nodding yes.
yes, sir.
Bailiff, could you get him a pen just to review it? Don't go anywhere. Just stay seated right
Safety
there.
hazard.
We'll
No
be in
pen.
recess for a moment. For the jail staff, thank you for your patience. We're going to go in recess. I'm going to leave the courtroom so you can review that. Bailiff, sit tight for a moment. And then when we're ready, meaning you've read it all, we'll come back on the record. Understood?
Yes, sir.
We're back on the record in 50-03-2501-F63, State of Indiana v. Rodell Martinez-Vizar. He is still with us in court. He has not moved, and states backed by Chief Deputy Prosecuting Attorney Nicholas Langowski. We took a recess for you to review the written form of the verbal questions I gave you earlier. And did you have an opportunity to read that?
Yes, sir.
Did you read through the entirety of it?
Yes, I did, sir.
So you read every word of it.
Yes, sir.
And what is your answer essentially to the last question on that page is, do you wish to proceed as your own counsel?
Yes, sir. I wish to proceed as my own counsel.
And did you sign that form at the space where your signature is?
I did, sir.
Can you hand that to my bailiff then? Yeah, go ahead, I suppose. Do you have any questions for the court about representing yourself?
I don't, sir.
Well, at this juncture, I will point out for the record that there have been some moments where Mr. Martinez-Vazar appears to answer questions in a way that is not direct, but yet seems to have some basis in an understanding of what will occur. So,
What? He what, Judge? When? When did this were we not listening to the same answers? His answers made it seem that he seemed to understand what was going on. Okay. All right. All right. I get it.
such as when he points out that there are witnesses that will be in the courtroom, he uses the phrase authorizing witnesses. It seems as though he understands witnesses will be called to testify. I've gone over his rights with him. He's understood those rights. I've looked at the advice for self-represented defendants, which I've read. I've read to him. He's answered all of those questions. He has then read at the recess and then signed. So I'll be filing the advice for self-represented defendants and finding that Mr. Martinez-Vazar's representation at this time is made knowingly, voluntarily, and intelligibly, and will proceed to the jury trial on July 9th. As it relates to the trial itself, Mr. Langowski, did you produce discovery as we previously discussed to the jail?
Yes, Your Honor.
Did you receive the discovery paperwork from the state, Mr. Martinez-Vazar?
Yes, sir.
Was there any follow-up discovery to that?
No, Your Honor. The only thing that he might not have received, which he should have, but might be in the possession of the jail, is there's a disc.
So there is some video or audio on a disc. Do you know that there is a disc?
Yes, sir.
Did the jail allow you to view that disc?
The jail did allow me to view that disc. I didn't get the chance to view it myself. I have not viewed it.
Did you say you have not or you have now?
I didn't get the chance. I haven't got the chance to view it.
It was his
myself.
choice not to listen.
And so
why.
they're going to let you do that? Because it sounds like they already tried to let you do that.
Oh, yes. They made it clear to me I could view the discs.
Why haven't you watched it yet?
I haven't watched it yet. I've been studying my paperwork.
Well, what I'll just tell you is make sure you watch that before the trial, because the state may use that as evidence and they may want to present that here in court. And so you need to know what is on that video to know whether you should object or not. Understood?
I understand.
Are there any other witnesses that need to be added that are not part of the discovery now that the state's aware of?
No, Your Honor.
Mr. Martinez-Vazar, I know I asked you this earlier, but do you have any witnesses you're planning on calling?
I don't, sir.
Does the court need to issue any subpoenas for you on your behalf?
No, sir.
Do you have any paperwork or what we would call discovery, meaning evidence that you're anticipating submitting?
No, sir.
You're under no obligation to present any of that, but I did want the state to be able to have that if you were planning on presenting some piece of evidence, because they should be able to see it before the trial. Not that I should see it or the jury should see it, but that the state should be able to see it so that they know what you're presenting.
Before.
So if you find you have some evidence, make sure you send that to the state at your earliest convenience. Okay?
Yes, sir.
Now at the trial, what will occur first is that we will pick a jury. Prior to the trial, you will receive juror questionnaires that have certain information redacted from them. That will be the personal information of the jurors, such as their location, their phone numbers, emails, and their full names. You'll have essentially their initials as well as a number, and then basic information about them and their responses. You'll receive those prior to the trial, so you will know who the jurors will be in general form. The state will also be presented those questionnaires, and then they will be permitted to ask questions of the jurors during jury selection. You can then also ask questions of those jurors during jury selection. You'll be asking about any sort of bias or preconceived idea about what jury selection looks like in a criminal case. You'll be able to see the state ask questions, and so you'll be able to understand generally what we're trying to figure out. Essentially, can they be fair and impartial in your specific case? On the desk in front of you will be a form that is called Juror Challenge Form, and you will fill out that form to tell the court whether you want a juror removed from the prospective panel. This is a level 6 felony, so we are selecting 6 jurors plus 1 alternate. What that means is there will be more than that number of jurors in the jury box to your right in the courtroom, and you will be able to remove a juror that you believe is not fit to serve or for any other reason that you deem appropriate. Those are called peremptory challenges, and you're entitled to 5 peremptory challenges. The state is also entitled to 5 peremptory challenges. You can then make what's called a cause strike, where someone says something that you believe disqualifies them from service. And then you can argue why that is a cause strike. After the jury is selected, they'll be sworn, and then the state will present an opening statement. You'll be given an opportunity to present an opening statement, but you're under no obligation to do so. Once the opening statements are completed, then the state's presentation of evidence will begin. As you mentioned, there will be witnesses called. The witnesses will be sworn and placed on the witness stand, and then the state will ask them questions. During their testimony, you will have the option to object to any testimony that you believe to be objectionable. Those are governed by the rules of evidence. You can make those objections. We'll hear any arguments about them, and I'll rule on the objections. Once their, meaning the state's presentation of evidence is closed, you'll be then given an opportunity to present any evidence. We will do this first outside the presence of the jury so that you can let the court know whether you're planning on calling any witnesses or presenting evidence without having the problem of the jury seeing that. And then once you've made that decision, if you call a witness, we'll announce that witness. If not, you can announce that the defense is rested as well. After the presentation of evidence, then we'll go into closing arguments, first from the state, then from you, then back to the state. And then right before, I'll read them instructions. As I've outlined the procedure of the jury trial, do you have any questions over that?
No, sir.
You will receive those juror question forms before the trial. You will also receive what's called a set of preliminary and final instructions. Those are instructions the court is anticipating giving to the jury. As you'll see, once you read them, they are about the general procedure of the case. So they will have general information, and they are written in a fashion that is not to encourage or discourage any particular verdict. They're neutral in form, and they advise the jury on the law in the case. If you have proposed jury instructions, you can submit them to the court, write them out, and then provide them to the jail staff, and the jail staff will forward them to the court. I must receive those prior to the beginning of the jury trial. Understood?
Yes, sir.
This is less about the trial, but it is important nonetheless. You're in the typical jail outfit, jumpsuit. You have your
Hold on before we get into his jail outfit, because that's a whole thing, guys. We're about to go through a whole process over this. It looks red. I said orange, and it's clearly red. Well, you know, I make mistakes. So he does not stream every day. He does not. I have every single reminder of everything on that I can possibly get to make sure that I get it. I don't see a way I won't get it as long as he streams. And you can only, you know what? Let me just tell you something, guys. If you want to see this trial, you can only see it here because ain't no one else get this judge for no reason. Only me, just me. So listen, if you guys want to be helpful, July 8th, remind me. No one's going to remember, but hopefully I do. Oh yeah, this is okay. Now we're going to get into his prison garb. I don't know what to say.
Shackles on, etc. You can be presented in clothing of your own choice that is not in that fashion, if you so choose. Do you have clothing at the jail that is appropriate to bring into court?
I don't, sir.
Do you have someone that can bring the clothing to the jail for you?
No, sir.
What size shirt do you wear?
Yeah, I wear extra large.
Do you know what size a button-up or a shirt with a collar you wear?
I don't.
So extra large shirt, correct?
Extra large T-shirt.
What about your pants? What size pants do you wear?
He wants an extra large Motley Crue t-shirt, please.
I'm not too sure. It might be extra large.
Do you know your waist size?
No, sir.
Do you know the length of your inseam?
No, sir.
Come on, who would have died laughing if he said all that? And then he gave the length of his inseam. That would have been hilarious.
How tall are you in general?
Generally, I think I am about 5'9".
What shoe size do you wear?
I wear size 10.
Daddy knows because his kicks. He knows.
If you prefer to be presented as you are, the court will certainly allow the sheriff to present you in that fashion. However, my presumption would be that you be brought here in some clothing that will be provided to the jail, and then we'll make sure that you're brought in that clothing. Do you have a preference on the way you're brought to court?
T-Rex.
I wish to proceed in jail clothing.
You do not want to have regular clothing, street clothing, so to speak?
No, sir.
Why not?
I haven't had any second option, any second
What?
adjustments.
I'm giving you the option of having clothes given to you.
Yes, sir.
And what you're telling me is you do not want that.
No, sir.
You'd rather have clothes given to you that you can wear into court today, or I should say at the trial.
I'd rather proceed to trial in my.
So the mic messes up here, so we don't really know what he says for a little bit. But what he means is he drips. He drips in his prison gear. He's fire.
My jail suit.
And again, why?
I'm proceeding in that fashion.
Do you understand that the jurors may negatively view that?
Yes, sir.
And why do you want them to negatively view you in your jail outfit? Especially when the court's offering you other clothing.
Correct. Yes, I wish to proceed in this fashion, in the jail fashion, because it's my first choice that I proceed to take. It's all I also don't have any second take within the witnesses against their eyesight.
Are you referencing that they would be able to see you in the courtroom?
I'm referencing the witnesses in their favor.
Help me understand that.
Me too. I can't
I'm
hear it.
referencing the witnesses to their right to witness this for in the court system.
And you brought this up because of the clothing. So why is that relevant with the clothing?
Yes, sir. It's because I have an issue with the
Well, I'm glad we covered it at least, and you've made your decision. As you pointed out, it's your decision and your choice. So the court clearly will, for the record, note that the court offered to have Mr. Martinez-Vizar presented in street clothes and non-jail garb, and he has declined and explained why he does not want to be present in street clothes. And the court will honor his wishes and his choice and will not be presenting anything to the sheriff's department. For your knowledge, Mr. Martinez-Vizar, we will allow you to remove the belt from your waist and the shackles so that you're not having to move, making all the noise in the courtroom here. So you will be able to be free to move slightly. I mean, obviously the sheriff's department will be here to physically restrain if needed, but you'll be able to stand and walk without having the jail shackles on. I've covered essentially everything I'd like to cover today. Mr. Langowski, is there anything else from the state's perspective?
No.
Mr. Langowski, we see him in Christofina's courtroom a bunch.
Yeah.
Mr. Martinez-Vizar, do you have any further questions?
No, sir.
At this juncture, I'm not going to schedule a motions and instruction hearing for the Monday afternoon before the 9th. Based on the record in this case, it does not appear to be a hotly litigated situation, and so there's not substantial pretrial motions that need to be addressed as of now. In the event the state or Mr. Martinez-Vizar files any motions, I will take those up, or if there are proposed jury instructions, the court will hear those the morning of the trial. We'll be here at 8:30 on July 9th, 2025 to begin the trial. The Sheriff's Department will arrange for your transport here and arrange for you to have meals throughout the day. We'll also give you some notes to be taking. So you'll have paper so you can take notes on the pages about the testimony and evidence in the trial. What the court's going to do for you is the day of the trial, I will be presenting you an entire book of the rules of court that'll be on your desk. So you'll have access to the entirety of the rules of court.
On the day of trial, we'll tell you what the rules are, and it's an entire book on the day of trial. But don't worry, they're going to give him something before trial.
Leading up to the trial, I'm going to send to the jail an entire set of the rules of evidence. That'll be a printed form for you, so you'll have the opportunity to read those rules of evidence before the trial. If you need further documents or legal authority, you can work with the jail staff to view the law library they have. And if there's something specific you are wanting, you can write the court. But I will send you the rules of evidence, and on the day of the trial, you'll have the entirety of the rules of court on the desk with you. Any other questions?
Seriously, I hope it just takes 2 hours or an hour and a half. Like, I promised you guys I wouldn't do a trial. So it has to take an hour and a half or less, or I'm going to be a big fat liar, which is fine. I lie all the time.
Questions, sir?
No, sir.
I'll remand you back to the custody of the sheriff. I appreciate the Sheriff's Department's patience and transport here. I'll see you on July 9th at 8:30.
Okay, sir. Yes, sir.
Thank you.
Well, Judge, you tried All right. This next one gets good like halfway through.
Mr. Cripe, can you hear me?
Yeah. Can you hear me?
Okay, yeah, hang on a minute.
Whenever Michael Cristofino looks at your paperwork this long, you might not be in the best position right now.
2001, 2109 F5201, State of Indiana versus Charles T. Cripe. Mr. Cripe, raise your right hand. Do you swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
Yes.
State your name for the record.
Charles Craig.
Thank you. Show the defendant appears in person from the Elkhart County Correctional Facility and by his attorney, Marlena During, both by WebEx, State of Indiana, in court by Deputy Prosecuting Attorney Lucas Shoemake. Oh, Ms. During, tell me what you want to do. Go ahead.
Your Honor, I've met with.
I love Judge Cristofino. I just do. I always watch him in secret. I don't play him for you guys much because, you know, it's long and drawn out, but I love him.
With Mr. Cripe, and it's my understanding that he wants to admit to the probation violation that was filed back on, I believe it was January of 2024.
Okay, so before we do that, let's make a little record on this. I got a letter from Hendricks Behavioral Hospital that Mr. Cripe had been restored to competency. And so we are in a position where the court can find that he is competent to stand trial. Do you agree that Mr. Cripe is competent to stand trial, Ms. During?
Your Honor, I do agree. When I met with Mr. Cripe, his mental status was tremendously improved from previous times when I had met with him. We were able to discuss the nature of the violation. He understands that he was, in fact, having a mental health crisis at the time, and was able to, talk freely with me about it, recognizing some of the limitations that he was experiencing previously. So I do feel comfortable proceeding.
Any record you want to make on that, Mr. Shoemake?
No, Your Honor, thank you.
Mr. Cripe, I'm finding you competent to stand trial as your competency was restored at Hendricks Behavioral Hospital. Now, your attorney has indicated you want to admit that you violated, let me get back to what it is. That you violated your terms of probation. Is that what you want to do?
Yes.
Before I can accept your admission, I must make certain you understand your constitutional rights. The state must prove any alleged violation by a preponderance of the evidence. You're entitled to have a trial in open court just as you're having right now. You're entitled to be represented by counsel at all stages of the proceedings, just as Ms. During is representing you now. You're entitled to confront and cross-examine any witnesses that testify against you, and you're also entitled to subpoena witnesses at no cost to testify on your behalf. Are you telling the court you understand your rights, you're waiving those rights, and you're admitting that you violated probation without a trial?
Yes.
Yeah. Thank you. Factual basis, Ms. During, go ahead.
Sure. Charles, do you agree that you were originally sentenced on this matter back in February of 2023?
Yes.
And do you further agree that at that time, Judge Bowers imposed a 4-year sentence that was suspended on 4 years of probation?
Yes, ma'am.
And you understand that as a condition of your probation.
I don't get Judge Bowers enough here, guys. Maybe I'll focus on him this week. If is it a him? Judge Bowers. I see the name in the list, but I can't place the face. Maybe I should get them.
You needed to report for appointments, but you also needed to cooperate or complete any evaluations or treatment that was court ordered.
Yes, ma'am.
All right. And do you agree with me, Mr. Kripe, that there were at least 3 separate occasions where you did not appear for probation appointments?
Yes.
And you understand that by missing those appointments, and again, I understand there were some circumstances going on, but you do agree that missing those appointments violated the conditions of your probation.
Yes, ma'am.
In addition, the court had ordered in December of 2023 that you needed to participate in an inpatient treatment program as, again, a condition of your probation, and you were not willing to go into inpatient treatment at that point in time. Is that correct?
Correct. Yes.
So you acknowledge by refusing to go into that inpatient program that also violated the probation that we've been talking about.
Yes, ma'am.
Okay. I don't have any further questions, Your Honor.
Mr. Shoemaker, any questions?
No questions.
Mr. Kripe, I'm going to find that you waived your rights, your right to trial, and that you admitted violating probation specifically by missing appointments and by refusing to complete inpatient treatment as recommended and ordered by the court. Do you want to go forward with sanctions today, Ms. During, or do you want to get reports, or what do you want to do?
Your Honor, I'm on the fence about that. I know the original recommendation was for Mr. Kripe to be ordered to go into the inpatient treatment until stabilized and then be returned to probation. But obviously that's been quite some time ago since that recommendation was made. So if you would prefer to see updated recommendations from probation, I completely understand. On the other hand, given that he has been restored to competency at this point, and I think he does understand the importance of complying with court orders and probation's orders, I'm comfortable proceeding if the court is.
How many days has he been incarcerated? Do you know? Did you figure correct?
I did, Your Honor. He had 530 days at the time of sentencing, and by my calculations, he has another 402 days in custody. So he has served 932, and I believe he would have 163 days left of his original sentence.
Yeah, the 932 is without good time, correct?
That's correct. That's just his real
932
time.
plus good time.
Correct.
I don't know, but they should say. I just haven't paid attention. I just don't pay attention to that. I just like what this judge is about to say to him. Hi, G-Men.
Where does he want to do his inpatient treatment at?
He is previous.
That's not 100% true. I know his charges right now are probation violation. I don't know what he's on probation for. It was 2 years ago, and there was a lot of competency issues since the time that he got charged and regained his competency and was put on probation. So I just don't know.
Worked with Oaklawn. And again, probation had recommended, and now the name escapes me, who they had recommended
Maple.
the inpatient treatment.
Maple
Was it
Heights
Maple?
Behavioral, wasn't it? Mr.
Maple.
Grape,
Are you willing?
Mr. Grape, you're shaking your head up and down. Maple Heights Behavioral, isn't that where Oaklawn wanted you to go?
My probation officer mentioned Maple City something,
Okay,
and I had been trying to get in there, but that was on a wait list.
okay. You got a place to live, Mr. Kripe?
I'm not sure.
You got a job lined up?
I have a cell phone. Once I get out of here, I can make calls to my parents and other family members and see if I have a place to live and go from there.
Hold on a minute. Ms. During, are you available June 12?
Let me look, Your Honor. I am.
Okay, Mr. Kripe, listen to me. I don't want to set you up to fail. You are at the last end of your sentence, okay? You got to get a hold of your mom or your dad or somebody. You got to have a place to live. I can't just release you so that here I go again. I've got one more struggling person with mental health issues living homeless on the streets. You got to see if you can live with mom and dad or somebody, okay?
I have a plan that involves a chaplain.
Okay?
If I don't have my parents' support, I have Faith Mission.
Yeah, okay, that's like, that is, oh man, Mr. Kripe, that's just really, let's see if you can't get a better plan, okay? I want you to come back June 12th, see if you get a better plan. I'm gonna see if I can I'm not gonna order ECCC and MCC. It's pointless. Counsel is pointless. He's got 160 some days left to do.
MC Hammer?
It's pointless to put him on community corrections.
I agree.
I mean,
I can report for probation. I can find a way. That's all I have to go on.
I want to make sure you got that lined up. Okay, I'm gonna have you come back June 12th. I'm gonna tell you what, Mr. Kripe, get stuff lined up. We'll see if we can do that.
I have a problem.
The other thing we could do is we could discharge him.
And are you guys ready to fall in love with the judge? Here we go.
That's the only way. I can't contact my parents until I leave here. I have a phone once I leave here. I don't have a phone in here.
Your Honor, quite honestly, that was, kind of what I was leaning towards. I understand that it puts him in a very tenuous position. However, the options that are available to the court as far as what to do with
Thank you,
him,
Monica. Thank you so much.
I think are extremely limited at this point.
I'm going to do my best.
Hey, Mr. Kripe, stop talking.
Okay.
Let everybody who's got a law degree talk, okay? Mr. Shoemaker, what are your thoughts?
No.
We are
And that's why I got this whole clip. Oh man.
very reluctant to agree to just to release him at this point, given the fact that he was just restored to competency. I don't want to set him up to fail. He doesn't sound like transportation, a job, even a place to stay.
Yay, thank you, Fuzzy.
I mean, the
Thank
recommendation from probation is, inpatient treatment, and it looks like in their supplemental violation, they're recommending that he remain in custody at the correctional facility until he can be transported to this Maple Heights Behavioral Hospital. So, I mean, even probation is, at least at the time of the filing, is recommending, further supervision of Mr. Kripe.
How long was the wait list, Mr. Kripe? Your turn to talk. How was the wait list when you were looking at this?
They didn't give me actual times on anything, and I was trying to see a psychiatrist there.
Okay, now let people with a law degree speak, sir.
I wasn't trying to get inpatient treatment.
Okay.
And Your Honor, the only thing I would add to Mr. Shoemaker's comments is that while I completely acknowledge that was probation's recommendation at the time, the intervening event since then is that he has been placed into an inpatient setting, through the court's placement regarding the competency issues. And so, again, with my dealings with him, we wouldn't be having this discussion if there had not been a successful mental health intervention, which has already been completed.
Right. Mr. Kripe, are you on
for a while?
medication? Don't tell me what it is. Just tell me if you're on medication.
No.
No? Didn't the state hospital recommend you be on medication?
They were putting me on medication that didn't really do anything. and they stopped once I left.
Okay, here's what we're gonna do. You're gonna come back and see me June 12. I'm gonna try and get an update from probation, and you're gonna try and get some more definite, like, I'm living here, I got a job lined up here, and then we'll talk about what we're gonna do. Mark, this call's coming on for, I had it just on for status conference. Defendant appears in person from the Elkhart County Correctional Facility and by his attorney, Marilena Durning, both by WebEx, State of Indiana, in court by Deputy Prosecuting Attorney Lucas Shoemake. Court finds that the defendant has been restored to competency.
Thank you so much, Scott. I appreciate it.
At the Hendricks Behavioral Hospital, and that the defendant is now competent to stand trial. Defendant waives his right to trial, and admits violating the terms of probation, specifically by missing appointments and by failing to participate in inpatient treatment as recommended and then ordered by the court. Court orders probation to
Thank you
provide
so
an
much. Thank you.
updated progress report, in particular as to whether the defendant would be accepted back onto probation. Court resets this matter for further hearing June 12, 2025 at 8:30 a.m. Get as much done as you can, Mr. Cripe. Ms. During can assist you, but get as much done so we've got a plan. Okay?
Sounds good.
No,
See how that works
that's
out.
fine.
Thank you, Ms.
Right,
During.
that's-
Ms. During,
thank
if
you,
you
Your
got
Honor.
anybody?
That's what you're supposed to do, I think, right? Join through YouTube. That's a good idea. That's how everybody else is joined. All right. This next one's not great, but it's only a few minutes long. So it's just frustrating because what do you got to do? I mean, I just don't know why she's not in jail.
And so there was 2 refusals.
Nothing. Thank you. Again, August 21st, 2025 at 9 is the status hearing. June 30th, 2025 at 5 p.m. for your probation appointment. Stay in contact with Mr. Worthley in the meantime, and then continue to report to your probation officer as ordered. Thank you, sir. Thank you, Mr. Worthley.
Thank you.
It looks like my audio detached. Oh, no. I don't know. It may be the audio detached.
Ms. Solomon?
Morning, Ms. Holloman. Come on up, ma'am. This is 50D03-2304-F6102, State of Indiana v. Jaylena Solomon. She's present with us in court in person, and we are scheduled for an initial hearing on a violation of probation. And Ms. Solomon, I'm going to be a little transparent in my thinking here. This is not the first, not the second. This is the third motion to revoke probation that's been filed. And so I'll abbreviate some of the discussion with you, but make sure you understand the circumstances you find yourself in and the rights and the range of penalties, et cetera. But my point in saying this is I've gone through those things with you twice now, and this is now the third violation that's alleged. And so I can abbreviate some of that discussion. But can you raise your right hand? Do you swear or affirm under the pains and penalties of perjury to tell the truth, the whole truth, and nothing but?
Okay, so when I get Indiana, every second the docket goes by, the sound separates. And if you've been watching my channel for any length of time, you've seen me struggle with this forever since I started. So it looks like this was near the end of the clip because the sound is completely separated from the audio by a good 20-30 seconds. So just watch or listen, but don't do both.
But the truth, so help you God.
Yes, sir.
Please state your full name.
Jaylena Ray Solomon,
What's your date of birth?
22183
What are the last four digits of your social security number?
4346.
Present in court as I went through another motion to revoke probation just before your case, correct?
Yes, sir.
And you heard me outline the rights that that individual has,
Yes,
correct?
sir.
And you have those same rights. Do you understand that?
Yes, sir.
Do you have any questions over those rights?
No, sir.
Those are in fact the same rights I've gone over with you at prior violation hearings as well, correct?
Yes, sir.
And the range of penalty on this offense is listed in the motion to revoke probation in the sense that there's 730 days that was suspended, and you have all but 10 days remaining on the suspended sentence. And what that means is you previously served 10 days in the Marshall County Jail, and so those 10 days will come off of that suspended sentence, but now 720 days becomes the effective range of penalty. Do you understand that?
Yes, sir.
In regard to the violation itself, it outlines a alleged violation of term number 7 that on May 15, 2025, you submitted to an oral swab which tested positive for THC and buprenorphine. And it notes here that there is a prescribed, this is her prescribed medication for the buprenorphine. So the alleged violation is for the THC product that was in the alleged failed drug screen. Ms. Solomon, I'm not asking you agree or disagree, but do you understand what it is that would be a violation of your probation if it was true?
Yes, sir.
Ms. Turnage, what's the probation department's recommendation on this case?
Your Honor, after discussions with the state, the recommendation is going to be 90 days, 45 actual days, Marshall County Jail, and terminate probation.
Ms. Lowe, is that in fact what you would recommend as well?
Yes, it is, Your Honor.
Ms. Solomon, to review where we find ourselves, that's what the recommendation from the probation, the state is. You have the right to be represented by an attorney, and so you can hire your own attorney or ask the court for a public defender. You can alternatively say, I'd like you to accept that recommendation, but if you do so, you'll have to admit to the violation and then ask me to accept that as essentially an agreement of the parties. And if you ask for an attorney or want to hire an attorney, I'll certainly give you time to do that. And I'll have to schedule some hearing dates to have this case moving forward. You also have the right to a fact-finding hearing. So if you simply contest the violation and want this matter to be heard at a fact-finding hearing, I could schedule that as well. The intervening issue with that is your representation and your attorney status, because you may want to be represented at that fact-finding hearing. So we'll have to negotiate that and figure out how you want to proceed this morning. So I suppose the first question is, what is it you'd like to do in regard to your attorney representation? Ask the court for a public defender, hire an attorney, etc.
If I could get a little bit of time to hire an attorney,
Okay. And how long do you think it'll take you?
maybe 30 to 45 days or so to come up with the money.
Are you still employed?
Yes.
You've been employed at prior hearings, if I remember right. So that's why I asked.
Yes.
Anything changed about your employment status?
No, sir. I do get a garnishment that's 25%. So I got to kind of work around that as well.
But in 30 to 45 days, you think you can have the attorney hired?
Yes, sir.
All right. So what I'm going to do is simply note a denial of the violation and that you're asking for additional time to hire an attorney. In looking at the calendar, 30 days is right around June 23rd. I apologize, July 23rd. And so what I'll do is schedule this for a pretrial conference on July 30th. That's just over 30 days away. And if you've hired the attorney by then, the attorney can enter their appearance and be here at that pretrial conference. Alternatively, if you've not hired the attorney, then you must be here to tell me what your efforts have been. Understood?
Yes, sir.
Now, the status hearing I'm going to schedule to follow up on this case is also going to be scheduled a little bit further out than the pretrial. I'll schedule that for August 28th, 2025. That'll be at 9 a.m.
Okay.
Now, do you have a probation appointment scheduled?
Yes, sir.
When is that?
I believe it's July 26th, 28th.
At what time?
5:30 p.m. 5:30 p.m.
July 28th at 5:30, correct?
Yes, sir.
Correct?
Yes, Your Honor.
The reason I bring that up is you're going to have obligations to the court to appear at hearing dates. You also have obligations to probation, so make sure you continue to appear at all probation appointments.
Yes, sir.
Any questions, ma'am?
No, sir.
You're free to go. Thank you.
Thank you.
She's going to jail, guys. She's going to jail. She has to be going to jail. She just has to be going to jail. Seriously, you can't just, no. I'm going to just keep in my head that she's going to jail. No, the audio is just so separated from actuality that we were just behind the times. Told you to watch or listen.
Betty's place.
I said don't do both. Y'all did both, didn't you? No one listens to me. All right, we did this guy or girl yesterday. Who did we do yesterday? Oh, look at that hair. Oh, let's do this one. That's all I had for today. So I'm just going to throw in a little bit of Georgia since we still have Georgia. I'm always playing video games. Always. I'm playing 2 or 3 right now while I'm on with you.
All right, court calls it this time 2 folders. I have 25R3832, which is on my revocation calendar. And I also have a new accusation filed today, case number 25R3938. I'll note for the record, you are Mr. Taylor?
Yes, sir.
Mr. Taylor is standing at the podium with Mr. Deal. Mr. Deal, what's your announcement on these 2 cases?
Your Honor, this is Mr. Powell, Joseph Powell,
What did I say?
Taylor.
Oh, okay. I'm sorry. That's your middle name. Okay. I picked up Taylor, not Powell. Joseph T. Powell. That's you. Sorry about that. That was my bad. All right, Mr. Deal, what's the announcement on this one?
Your Honor, the state has filed a new accusation, 25R3938. It actually is listed as possession of firearm by a convicted felon. It should be possession of firearm by a first offender. That statute, the difference is it's a 1 to 5 sentencing range versus 1 to 10. But we would agree that that can be changed, modified on the record to reflect that.
Very well. So ordered.
He will enter a guilty plea to that offense, waive indictment, and be given a 3-year sentence. Department of Corrections.
3 years to serve?
Yes, Your Honor. That charge tracks count 1 in the probation revocation petition. By pleading guilty to that, he would, of course, be admitting to count 1 in the petition. We anticipate his first offender status would be revoked. He would be resentenced to 3 years to serve, and that would be currently with the new charge.
Anything to add from the state?
No, Your Honor, that's correct. And we'll make the correction as to it being a first offender possession once he signs the plea.
All right. All right, Mr. Powell, it appears that you and Mr. Deal and the DA's office have been discussing these 2 cases and have reached this joint recommendation. I'm going to have a lot of questions for you in just a minute, Mr. Powell, but so far, has everyone said what you expected them to say?
Yes, sir.
Before the court can get to the disposition phase of these 2 cases, the court must first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this, but just as important, that you understand all of the rights that you'll be giving up if you complete this guilty plea and these admissions here today. If at any point during this process you don't understand my questions or you need some more time to talk to Mr. Deal, just let me know and I'll give you all the time that you need within reason. You understand everything so far?
I need help. It's
I
too
best you're
hot.
able, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
You put your hand down. Mr. Powell, do you understand this is both a probation revocation of your probation case and a guilty plea on the new charge filed in today? Do you understand that?
Yes, sir.
And do you understand the sentence recommendation of 3 years to serve on both cases? Do you understand that? And is that what you agreed to plead guilty to before you came out here to the podium?
Yes, sir.
Before the court can determine or decide whether or not to accept this recommendation, the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up.
Happy birthday, Casey Carey. Happy birthday. Yes, I have AC. It's just very hot.
if something happens that you don't understand. First of all, as to some background questions here, Mr. Powell, preliminary questions. Are you under the influence today of any intoxicants like alcohol, drugs, narcotics, or prescription medications?
Yeah, if you make your hair just like his, it's not so hot. It actually feels much better. Thank you, dude. Thank you.
No, sir. Is your mind clear today?
Yes, sir.
Do you know where you are and what you're doing?
Yes, sir.
Can you read and write?
Yes, sir.
You understand the court does not have to accept the sentence recommendation.
Yes, sir.
Other than the sentence recommendation, has anyone promised you anything to get you to agree to this revocation and to this sentence in the new case?
No, sir.
Has anyone threatened you or frightened you to force you to enter this guilty plea and these admissions here today? Concerning your guilty plea on the new charge in case number 25R3938, do you understand that is a felony and it has a maximum sentence of up to 5 years to serve in prison with a range of 1 to 5 to serve in prison? Do you understand that?
Yes, sir.
And do you understand that you have a right to have a grand jury consider that case first? But my understanding is you wish to waive that right and proceed to dispose of this case today. Is that correct, Mr. Powell? Is that correct, Mr. Deal?
It is.
Very well. Mr. Powell, do you understand that on the new charge that we've been discussing here, you have the right to enter a not guilty plea and demand a jury trial wherein the state of Georgia must prove you guilty beyond a reasonable doubt? Do you understand that?
Yes, sir.
If you plead not guilty on the new charge, Georgia law guarantees you the right to a speedy and public trial by jury, a presumption of innocence that would remain with you throughout the trial, the right to confront and question all witnesses who accuse you. You have the right to subpoena your own witnesses and evidence in your behalf. You have the continued right, the right to the continued assistance of your lawyer throughout the trial. You have the right to testify yourself if you wanted to and to offer other evidence, but you also have the right not to incriminate yourself. You may testify or not, and you personally would decide if you testified or not. Do you understand on this new charge in 25R3938 that by pleading not guilty or remaining silent and not entering a plea, you would obtain a jury trial with all of these rights? Do you understand that?
Yes, sir.
Do you understand that if you plead guilty pursuant to this plea agreement, as you're doing now, that you will be giving up or waiving all of these rights? Do you understand that?
Yes, sir.
Now, concerning the probation revocation, that original sentence was dated September 23rd, 2024, at which time you received first offender status and received a 5-year probated sentence. Therefore, it is set to expire on September 22nd, 2029. Do you understand that, Mr. Powell?
Yes, sir.
Do you also understand that instead of agreeing to your probation being revoked, as you're doing now, that you can demand a formal hearing before this court in which the state of Georgia must prove that you have violated the terms and conditions of your probation by what is called a preponderance of the evidence, which simply means more likely than not? Do you understand that?
Yes, sir.
On the probation revocation, if you demand a formal hearing, Georgia law guarantees you the same rights that you would have in the trial on the new charge, except that the probation revocation would be tried before the court without the benefit of a jury, and the burden of proof is different, as I've already described. Mr. Powell, do you understand that by agreeing to this revocation, you're waiving your right to a formal probation revocation proceeding? Do you understand that?
Yes, sir.
And I may have asked you this already, but is this 3-year sentence what you agreed to plead guilty to before you came out here to the podium?
Yes, sir.
All right. Now, you're represented here today by Mr. Deal. Is that correct? Have you had enough time to talk to Mr. Deal about both of these two cases? Do you need any more time to talk to Mr. Deal about either of these two cases? Do you have any objection about how Mr. Deal has handled these two cases? Concerning your probation revocation, do you freely and voluntarily admit the facts about how you violated the terms and conditions of your probation as set out in, well, how many of these?
Count one, Your Honor.
Count one only. Do you make that admission here today, Mr. Powell?
Yes, sir.
Concerning your guilty plea on the new charge, do you freely and voluntarily admit your guilt on the new charge, possession of a firearm by a first offender probationer, because you are in fact guilty?
Yes, sir.
All right, Mr. Deal, see that his guilty plea gets entered.
know what I'm saying? That you put in the first and then you scroll in. Here's my question. Okay. Since I'm doing this. I can do it.
Is that sufficient, Chief?
This is my question. This fits down there.
Just to make sure. All right, yeah, that was not intentional, I'm sorry.
Just. And that's the reason why is because it does.
Yeah, you could, it wouldn't hurt just to get some call.
Like the seamless, clear seamless, it's just kind of strap around. Just grab some.
Powell is signing. There was one thing I neglected to mention. Our agreement is that this sentence can begin on April the 11th. It's complete credit for the time served since his incarceration.
Well, hello, Delight.
April 11, 2025.
Yes, Your Honor.
All right.
Sir, last year. Nice. So you didn't care
Facts of the case, please.
Yes, Your Honor. On the date alleged in the accusation before you, the Eastman Police Department was dispatched to the area over there near EMC and the GBI office here in Dodge County in reference to shots fired. Officer Sheffield with the Eastman Police Department responded first and found a male subject to be lying in the roadway suffering from a gunshot wound. Officer Shawcroft then arrived and spoke with the same individual. He was identified as Joseph Powell, who's here before you today. He indicated at the time that he didn't know what had happened and he had been shot. As the investigation continued, they followed Mr. Powell's blood trail, which spanned quite a distance from well past the GB office to up in the area of EMC. During the course of following that blood trail, they did confirm that it was his blood trail due to it going to areas where witnesses stated he had gone trying to ask for help. Also along that same blood trail, the officers located a firearm that had been ditched in the woods. That firearm had a drum magazine and the casings that were located at the area that Mr. Powell purported to have been shot at. Those casings were located and exceeded 40 shell casings and were consistent with the caliber of firearm that was located along Mr. Powell's blood. He was on probation, or is as of this moment on probation for theft by receiving a stolen firearm.
Mr. Deal, anything from the defense?
Your Honor, of course, this is initially brought in on a probation revocation. I believe this is the third time Mr. Powell has come to court. Of course, on revocations, we typically don't get much in the way of discovery, but we have been able to speak with the officers involved. We've looked at the photographs that we expect would have been tendered in evidence had we had a hearing. Discussed that with Mr. Powell, the burden of proof that would be on the state.
Drum magazine. That's what he had. Look at that. My Lord.
Day and what the consequences would be in the event that he had a hearing and the court found him in violation.
All right, do you have more, Mr. Deal?
We would just ask that you accept this recommendation so that he can put this behind him.
All right, Mr. Powell, do you have any questions about anything that's happened up to this point?
No, sir.
Is there anything that you would like to say? You don't have to, but you can if you want to.
No, sir.
Very well, the court finds that the plea has been freely and voluntarily entered in the new accusation and that the admission and the new guilty plea were made with a knowing, intelligent, and voluntary waiver of all of his rights, and the court finds there is a factual basis for both and will accept the recommendations. On the new case, 25R3938, it will be 3 years to serve in the custody of the Georgia Department of Corrections with the time to start April 11th, 2025.
Yes, Your Honor.
You have a period of 4 years to file a habeas corpus petition from the date this sentence becomes final, 30 days to file a notice of appeal or a motion for new trial. Do you possess a concealed carry permit for a firearm, Mr. Powell? And on the probation revocation, the court will revoke your first offender status and adjudicate you guilty on the underlying case, which was 23R3082. And you'll get the same 3-year sentence to serve in the Georgia Department of Corrections back to the same date. And also same notifications, 4 years to file a habeas corpus petition from the date that 30 days to file a notice of appeal or a motion for new trial. I think I clicked all the boxes. Did I leave anything out, Ms. Lowry?
No, Your Honor.
All right, Mr. Powell, that will conclude both of these cases. Probation, well, no, I guess you're going to go back to the sheriff's office for execution of sentence, but good luck to you, Mr. Powell. Thank you, sir.
Thank you.
Well, I hate to leave it on a frustrating one, but that one was frustrating. Guys, thank you so much for coming out today. I really, really, really appreciate it. And your generosity today is unbelievable. Thank you. I really appreciate it. I hope you guys have a great day. I love you. Well, 2 or 3 of you I'll see in OJ. The rest I'll see later. Hopefully I got a video out today too. And one quick thing, if you watch the video or a short, please, for the love of God, watch it to the end. Because if you close it early or swipe away, that's bad. If you don't watch it, that's fine. But if you do watch it, try and watch it to the end, please. I'm begging you. All right. Have a great, great, great day. Thanks, guys.
Got these lights that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Screaming tales late into the night. Her laughter feels just right. Even when my world turns gray,